Non-competition agreements or non-competes are becoming more and more common. Many employees are being asked or even required to sign them, and numerous employees are doing so. There are good reasons for this. From the employer's side, they provide protection for their investment in an employee that they have hired, trained, and developed, and who wants to jump ship and work against them for a direct competitor. For the employee, a non-compete can have devastating consequences. It can actually preclude them from working in their chosen occupation and locale for a significant period of time. As a result, there's a lot of information and frankly misinformation out there about non-competes. You may hear, for example, that they're not enforceable in this state because Florida is a right-to-work state. Those are two entirely different concepts. Non-competes are enforceable in the state of Florida. In fact, there's a specific statute that addresses them, and there's a lot of case law that interprets and applies that statute. However, based on the facts and circumstances of each case, that does not mean that the non-compete is always enforceable or enforceable to the full extent of the terms in the document. The very first issue to look at is whether that non-compete is actually signed by the employee. If it is not enforceable. There really is no substitute for professional advice on a non-compete, preferably before it is signed. For example, the document may be entitled Non-Competition Agreement, but it may actually allow the employee to work for a competitor, but just not to solicit customers or clients or disclose information of the previous employer. The non-competes will usually set forth the time and geographic restrictions in them. For example, 1 to 2 years, 50 miles, 3 or 4 counties. However, it is important to know that these restrictions can be challenged, and a court is empowered to reduce those restrictions based on the facts and circumstances of the case. If the court does so, however, the non-compete is still enforceable to the extent modified or lessened. Another important issue is the typical remedy that's sought by employers is a temporary or preliminary injunction to stop the employee from working for a competitor while the lawsuit is pending. Any significant delay by the employer in seeking that relief could be fatal to that relief and thus allow the employer to continue working during that time.